In this installment, Joshua Youssef Tawadros is being interviewed by me, Dina Pete, on the topic of the duty of good faith.
Joshua, in a perfect world, parties to a contract would always act honestly with each other. However, in the dog-eat-dog world of commerce, reality often differs. What does the legal concept of a duty of good faith on contracting parties mean for parties engaged in commercial transactions?
You're right, Dina. In an ideal scenario, contracting parties would act in a forthright and transparent manner. Unfortunately, that's not always the case. In fact, the Supreme Court of Canada has grappled with the interplay between principles of good faith and those of free enterprise. Essentially, we're now in a world of balancing fairness and integrity, while simultaneously supporting the terms of freely negotiated commercial agreements. Intertwining good faith with cold-hearted elements of contract can be messy.
Interesting. Could you give us a brief overview of the legal principles underlying the duty of good faith?
I can try. Our court system tries to serve both equity and law. Basically, our courts attempt to address fairness while also applying law. In contracts, even if one party may not have technically breached a contractual term, if the court finds that they dealt in an unfair manner, it could intervene. The duty of good faith in exercising contractual rights originates from these principles and was solidified in a 2014 landmark Supreme Court of Canada decision, which went a step further by ruling that an aspect of good faith dealings for contracting parties is the requirement to act fairly and honestly.
I see. So you're saying that they elaborated on what the duty of good faith means?
Yes. In a nutshell, the ruling from the highest court in our land clarified the duty by holding that contracting parties must not lie to or mislead each other regarding matters directly linked to their contractual performance. The duty of good faith requires parties to perform their obligations honestly and reasonably.
How exactly does that work?
Good question. Determining whether the duty is upheld depends heavily on the specific context of each scenario. Since 2014, subsequent rulings have emphasized that good faith will only be breached if the unfair dealing was directly linked to contract performance and was through active conduct that contributed to the misapprehension of the innocent party.
I think I kind of get it. How about if you provide an example of how the duty of good faith might apply to a commercial leasing scenario?
Okay, let's consider the duty of good faith in the context of lease renewal. The Ontario Court of Appeal recently tackled the issue of relying on the duty of good faith to validate a lease renewal despite the tenant having missed the renewal deadline. The court ruled that the duty of good faith will not grant relief to a party that failed to uphold its obligations due to its own mistakes. A party cannot rely on the duty of good faith to relieve itself of contract performance if the party did not uphold all its obligations.
Interesting. So the landlord's refusal to accept the late renewal wasn't a breach of the duty of good faith. This is all starting to add up, but, and excuse the bluntness, what's the bottom line with the duty of good faith?
Well, ultimately, Dina, the duty of good faith is rooted in equity. Our courts aim to reach the fairest and most just outcome. The core principle is that when exercising their rights under a contract, parties must act honestly and in a manner that reasonably aligns with the contract's intent. No fast moves, no chicanery. Basically, behave honorably, whatever that means.
That was Joshua Youssef Tawadros in conversation with me, Dina Pete, on the topic of the duty of good faith. If you would like to learn more, contact Joshua on our website, dv-law.com.
This audio recording was a general discussion and should not be relied upon as legal advice.